Hey out there, legal warriors, bad stop or bad cop. These are the two major ways you can kiss your DUI case goodbye. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, I'm getting asked all the time, how do I beat a DUI charge? How do I get a DUI charge reduced? How do I beat it altogether? How do I get it dismissed? And what I've come up with after 30 years of doing this job, remember I was a prosecutor in the past, it's really bad cop or bad stop are the ways that we can get rid of a DUI case, or the most powerful defense typically falls into those two categories. We could also say bad toxicologist, but it doesn't really rhyme with cop or stop. So that's a third way which we can cover as well. So let's start with the first thing, bad stop. What do I mean by that? Well, in most DUI cases, obviously the word driving is in there. So most of the time there needs to be evidence that somebody was driving. When I say most of the time, what does that mean? Can you get a DUI without driving? Well, you can get the same thing as a DUI without driving, a case called physical control. That means having the ability to make a motor vehicle move even if it wasn't moving. You can just sort of be asleep in the car with the keys, and that's the same as a DUI, but we're talking about driving under the influence. So bad stop is, what is the valid basis? Is there one for the law enforcement to pull over a vehicle that they suspect of DUI? And what's the most common, reason why someone gets pulled over? Well, it might be swerving, right? Weaving, changing lanes without a signal, having an accident, speeding, going way too fast, or even going way too slow. But where do we see bad stop? Well, one of the first things to think about is weaving within the lane, right? In Washington State, there's some case law out there that says weaving within the lane may not be enough to stop a motor vehicle, because the driving within a lane basically says you have to drive as entirely as practicable within one lane. You don't have to maintain an exact straight line. You may even be able to hit the side of the lanes a couple times. And so it's going to be case by case. But if all the officer has is weaving within the lane, and that's the basis for the stop, we might have a good defense to make that case go all the way gone. Another way we can challenge a stop would be what I would call a pretext stop, a stop that they're objectively stopping not because of the stated reason, but because they're actually looking for a DUI. Now, that's a tough standard in Washington State. There was a case back in the day called Ladson, Ladson, which set the standard for what a pretext stop is in this state. But an example might be a vehicle that is leaving a bar, and they take a left out of the parking lot, but they don't signal that turn. And let's say a lot of people don't signal that turn, but this happens to be at 2 a.m. and there's an officer sitting right there, and the officer stops that vehicle as it takes the left for the basis, you didn't signal your turn. Well, if we were able to get that officer to testify to the fact that, hey, I wouldn't normally pull over for that. It's out of a parking lot. A lot of people don't signal there. But the only reason I did it because they were leaving a bar and it was 2 a.m., so they must have been drunk. If they were to testify to that, that could make the whole case go away. And in fact, I did have a case years ago that went away altogether because that's how the officer testified. I'm sure they got better instructions. They'll probably never testify like that again. Another way we can see a bad stop is when someone calls in 911, right? The officer doesn't see any driving. Someone calls in 911 and they make sort of conclusory statements about why they are calling. It's something about reliability of informants. There's a case called Campbell out there, and we don't need to get into that. But informants are not necessarily presumed to be reliable. Now, a citizen informant is. So if it's a random person, we don't know who it is, that's called a citizen informant, so they have a level of reliability, versus someone that knows the suspect may have less reliability because they might have a motivation to lie. But ignoring reliability factors, we have to look at what the caller actually said to 911. If they said, hey, that driver did not signal a lane change, went 3 lanes to the right, almost drove someone off the road, and also hit the median, on the other side of the road, well, that's going to be objectively enough to show there was some type of traffic infraction to stop the vehicle. Because if the officer observed those exact things, those are so specific that they show a violation of the rule of the road. I moved all these lanes without signaling, they hit a barrier, whatever. Now, if instead a caller calls in and just says, hey, this person's driving drunk, or this person's driving like a crazy person, or this person is all over the road. Now, those aren't really factual descriptions of an infraction. There is no infraction for driving crazy. There is no infraction for being all over the road, whatever that means. That might be within your lane, which we just talked about. So if it's just a conclusion and the officer does not establish their own independent basis to stop a motor vehicle when all they have is conclusory language from the caller, the unknown or known caller, then that's a pretty good case where we can challenge that as a bad stop. And of course, the basis to stop a motor vehicle is just reason to believe that something is going wrong with the vehicle and the law, right? It's not even probable cause to stop, that's to arrest. It's reasonable grounds to stop and detain. So it's a pretty low standard, but there still needs to be something that is said. And your attorney, they may have video from a law enforcement agency's vehicle, such as State Patrol, and the video may not show what the officer claims it shows, and that one could be one way we make a case go away through what I call bad stop. Now, number 2, bad cop. What do I mean by that? That doesn't necessarily mean like an evil cop who's out to get you and is purposely trying to, violate your rights. It could mean that. Unfortunately, those things have happened in human history. But what it mainly means is a cop who's not doing their job correctly. Bad cop is that cop who does not properly inform the instructions for the field sobriety tests. It's the officer who does not tell someone that the field sobriety tests are voluntary, which could potentially get field sobriety tests suppressed. And what's a field sobriety test? It's the things that we know about. It's like, watch this stimulus as I move it back and forth. Can't even do it now. It's walking a straight line, standing on one leg, all those type of things are field sobriety tests. And the reasons why the officers ask or tell us to do those things is that gives them the probable cause needed for their arrest. They've already, hopefully, from their point of view, have reasonable grounds to stop you, but now they need to develop probable cause to effectuate an arrest for DUI. And so a bad cop can screw those things up. The most common is involuntary field sobriety tests, improperly instructed field sobriety tests. What else might we have? Well, a big one that most people don't know about is stuff that happens after the arrest, but at the police station. And that's when they're asking you to take a test of your breath, the formal breath test at the police station. There, the officer has to read you something called implied consent warnings, and that's through Initiative 242, so they might call it 242 warnings. But it basically informs the driver that because they're driving on roads in Washington, that they've impliedly consented to a test of their breath if an officer has reasonable grounds to suspect them of DUI. And they have to tell the driver you have the right to revoke that consent, but if you revoke the consent, certain bad things are going to happen to your license. They also have to tell the driver about their right to have an attorney, all these type of things they have to do as part of this breath test situation. And so if an officer does not read the 242 warnings, that's going to suppress the breath test, bad cop. And without a breath test, they might have a bad case that goes away or is more likely to get reduced. Additionally, we could have the officer not follow the state toxicologist rules as far as how they do the breath test. If you take a look at the top of your breath test ticket, there's going to be, where it says what your numbers are, it's going to be a little thing that says observation began, and that's going to be a time. For sake of argument, let's say it's midnight. They arrested you at 11:15 p.m. They get you to the station. Now it's midnight when the officer says, let me look in your mouth. Open your mouth, please. Raise your tongue, right? Do you have anything in your mouth? They either have to ask if you have anything in your mouth or look and see if there's something in your mouth. And then they have to actually check this box that says, I did that and there was nothing in the driver's mouth. But now they have to watch you for at least 15 minutes prior to the breath test. And that's not really defined. Keep their eye on you, right? If they turn their back to you, does that mean they're watching you? We would say it doesn't, that they didn't maintain constant observation. Because the state toxicologist says for the breath test to be valid that they have to show for 15 minutes before the test you did not put any foreign objects in your mouth, you didn't drink anything, you didn't vomit up anything, because if there's stuff in your mouth, that breath test machine may read mouth alcohol and not deep lung alcohol like it's designed to do. That's the only thing that is illegal, is to have the breath test give you a valid reading of 0.08 or more, at least for per se illegal over the limit. And so how does your defense attorney deal with that? Well, they might request breath test room video. Many of these breath test rooms have video. There won't be any audio, but they have video. And an attorney can request those, and we could watch and see what they did. So that's important. Also think about it. If you put something in your mouth, your finger, a pencil, you vomited something up, you went to the bathroom and they didn't restart an observation period, make sure your attorney knows, is that is another way we could use bad cop to try to make a case go away. I think the final thing I want to talk about at the station regarding bad cop is if you ask to speak to an attorney. If you ask to speak to an attorney, the officer is not supposed to listen in to what you're talking to your attorney about, right? Because the attorney on the phone, the public defender, the private attorney at 2 a.m, we're going to say, try to help you decide what to do. We're going to say, how much did you have to drink, right? If the officer's listening in, you're not going to say 4 bottles of wine. But if it was 4 bottles of wine, we need to know that, because it's going to let us know what to advise you to do. And so the case law would say that you have to ask the officer for privacy for there to be a consequence to him violating your attorney-client privilege in that situation. So if you ask to speak to an attorney and they put you in contact with an attorney, make sure you ask for privacy. And that way, if they are listening in and you're not free to say what you want to say, that could fall into bad cop, where you might be able to use that to make your case go away altogether. It's case by case. There may be other evidence they can use against you, but these are the things we want to worry about. Now, number 3, bad stop, bad cop, bad talks, which would mean, hey, is there a way us attorneys can get all the records from the state toxicologist to show that the breath test device wasn't working properly, or if you had a blood draw, that they're messing up the blood draw, not just the blood draw, but the anticoagulants in these tubes that they use, or whether or not they were stored at a proper temperature, or contamination by meth at the lab. All these things have happened recently, and so that's a little more technical, and hopefully you have a team of attorneys that can look into that, because it's tough to do. A lay person would have no chance to do it. You're going to have to be an attorney for a long time to even understand this stuff. But bad talks is another way we can get, hopefully, a better result in a DUI case than if they do everything perfectly. So what do you want to take from this? Well, you want to take with it, don't get a DUI, but if you do, pay real close attention to what happens. And the good news is you don't have to remember everything perfectly, because so many officers have body cams now, we can actually see what they did, right? But, we want to try to, not give them much evidence if we can avoid it. We want to follow instructions, but typically not field sobriety tests. And you're going to want to talk to an attorney while you're under arrest, so they can give you advice about whether or not you should take that breath test, or whether or not you should refuse. Although nowadays, if you refuse, it's pretty easy for them to get a warrant for your blood. So it's a complicated question. So I hope you never need this advice, but if you are in this situation, make sure to watch this video a couple times so you know what to talk to your attorney about. So if you found this useful, please like it, please subscribe. More people get to see it, more people get the help they need. More importantly, if you have a criminal problem in Washington State, feel free to reach out to my firm. We'll get on board, we'll identify a way forward, we'll also listen to what happened, and we will be there for you. Thank you.